There's been a big development in a lawsuit between YouTuber Jarvis and Austin McBroom, which is that Austin McBroom's attorney has filed a motion trying to withdraw from the case to stop being the attorney for Austin McBroom. I'm Kevin Kneupper. I'm an attorney at Kneupper & Covey. I've done a couple videos about this lawsuit, about what it is and about the chances that Jarvis could actually own Austin McBroom's YouTube channel if he wins it. And what is it about? If you haven't seen those videos, just a real short version. It is a boxing-related lawsuit, hence the thumbnail here, which is that Jarvis has sued Austin McBroom, saying that he was sort of the secret organizer of a celebrity or a influencer boxing event called the Battle of the Platforms, where like YouTubers would go box TikTokers. And Jarvis says that this was a total disaster, that he was promised $1 million to do the fight, and then he never got paid it. And he sued Austin McBroom, saying that McBroom's the one behind it. He and his dad and their company basically organized it. They didn't want people to know that they were the ones behind it because people, according to Jarvis, don't like Austin McBroom. I'll leave that up to the viewer to decide. Austin McBroom initially didn't show up to the lawsuit at all. So there was actually a default entered in the case, which means kind of a TKO in boxing terms. You didn't show up, so you just lose. And then Austin McBroom, kind of after that happened, shows up at the last minute, says, here's my attorney, I'm going to fight the lawsuit. And now the attorney has just filed something that says that he wants to withdraw as the attorney in the case and for undisclosed reasons. And I'm going to show you this motion and explain to you a little bit about what that's about, what it means for the lawsuit, and what it means for an attorney to withdraw from a case. So here's the motion, and if you don't know what a withdrawal is in a case, this is something attorneys are allowed to do. You may or may not know sort of how that works in an attorney-client relationship, but basically, like, there are situations where an attorney can just say, look, I'm no longer want to be your attorney. There are various reasons why that might happen. I'll walk through some of those. It's hard to read sometimes, like, what the actual reason is, because part of being an attorney is that there's this attorney-client relationship. You're supposed to keep things confidential. So if you decide, hey, I don't want to be this person's attorney anymore, you can't really go blab about it to the court or in public. You're not supposed to go file something and give sort of too much details in a way that would like reveal anything that your client has been telling you. There can be a lot of reasons, and just to like start out with a couple, like the most common one is probably you're not getting paid. So if an attorney is not getting paid, then they can go to the court and say, look, I don't want to be the attorney in this lawsuit anymore. In the context of a lawsuit, a lot of times you have to, and it depends kind of state by state or court by court, federal versus state. But it is kind of normal to go ask the court permission to withdraw, because in the lawsuit context, there are deadlines, there are things coming up. You can't just kind of disappear. And sometimes even after you tell your client, look, I don't want to represent you, even after they're not paying you, you may have to keep working on the case as the attorney a little bit. Like, let's say there's a hearing. You can see that there's kind of a hearing date listed here. And it's tomorrow, and I tell my client today, I don't want to represent you anymore, or even if I'm fired by my client, I might still have to show up at the hearing and basically tell the court that, but say, look, for now, even though there's this issue, I want to try to represent my client's interests. I want to try to, don't rule against my client, give them time to get a new attorney, whatever you need to do to sort of protect things, because you are still the attorney until the court says, no, you're not. And here's this motion that was filed by this attorney who had been representing Austin McBroom in this lawsuit with Jarvis. You can see the case is Jarvis Catry, which is his full name, versus Simply Greatness Productions, LLC, which is alleged to be Austin McBroom's company. And then et al. Just means there's some other people whose names do not fit in this little box right here. And those names are Austin McBroom and his father. And in California, a lot of these state court motions are done with forms. You can see the attorney fills out this form and then he explains what he's doing. He says, there has been a breakdown in the attorney-client relationship. The specific facts which give rise to this motion are confidential and required to be kept confidential. And then he cites a couple laws, and he says, and by the attorney-client privilege. If the court desires further information regarding the basis for this motion and for withdrawal, it is respectfully requested that the court hold an in-camera hearing outside the presence of all other parties. This action is still in its early stages. There's no trial date pending, and defendant will have more than ample time in which to retain new counsel. So what is the attorney saying here? So he's saying, first of all, I can't tell you what the reasons are in public, but if the court wants to know more, then the court can hold this in-camera hearing. An in-camera hearing is when the court that's like a Latin phrase that just means that you're looking at stuff sort of in private. And so the court could do that without allowing the public to be there, without allowing the other, like the attorneys for Jarvis to be there, and then kind of explain to the court, hey, here's the justification for why I can't be the attorney anymore. Is it that I'm not getting paid? Is there some ethical issue? And I'll show you the rules of professional conduct in a second that he's talking about here, which explain kind of like a lot of the reasons why this can normally happen or not happen. It is hard to tell here exactly, like there is no real way to know because the attorney, and this is proper, he's doing what he should do, which is not tell the court about like all the details here if there's something going on. So it could be not, like no big deal. It could just be not being paid. It could be something that there's something that he's being told to do that he doesn't want to do. It could be all kinds of things. We can't really read that much into it, but we do know that Austin McBroom is now fighting this lawsuit without an attorney, and you can see they schedule a hearing for it, and he kind of says like, I'm also asking to be relieved as counsel for this corporation. This is one a little bit interesting thing if you're a law student or a lawyer or like in law school or whatever. You see he says that he files these substitution of attorney forms for the two other defendants, the individuals, Alan McBroom and Austin McBroom. So what that means is they are now representing themselves. He's filed these forms and they basically say, and they're signed by, I'll show you one of them. They're signed by Austin and Alan. And now they basically are allowed to just go represent themselves for now as their own attorneys. That's called a pro se defendant, which means for yourself. Again, more Latin, which attorneys just, I don't know why we love it. We just do. And then he says, I can't file this form for Simply Greatness Productions LLC because it is an LLC which cannot act as its own counsel, and it has not yet found new legal representation. So when you're trying to withdraw as the lawyer for a corporation, corporations cannot just go into court and represent themselves because there has to be a person behind it. And it's based on the idea that, like, let's say Austin McBroom is the CEO of this company. He's not a lawyer, so he can't go represent a corporation, and neither can Alan if they're not lawyers, which means they can't just go in and be like, I'm also representing this company because the company is legally a separate entity. It has to have a lawyer represent it. It can't represent itself because it's not a human being. And the human beings who work for it, if they're not lawyers, cannot come in and do it. So the attorney has to do this separate thing for Austin, Alan, and this corporation. Now, this is generally bad for all of them because you don't want to be running around without an attorney. If they're not paying the attorney, which would probably be the most likely thing, that creates a couple problems. One is that they may not have the money to go respond to this, which means that Jarvis may be getting his $1 million judgment. And then, as I discussed in a previous video that I'll link to in the the description of this one, he might go own the Ace Family YouTube channel. That is theoretically possible and something that could happen. And then we might just start seeing the Jarvis family on what used to be the Ace Family. And the other problem that this creates is that I will tell you, like from a practical perspective, if an attorney sees that there has been a withdrawal in the case, that's kind of a red flag for something, right? A new attorney. So this attorney is gone. He doesn't want to be on the case anymore. If you're an attorney looking at taking this on, you have to look at that and go, okay, there's some reason here. And if the reason is the guy's not getting paid, well, that's a problem for me because I want to get paid. Or if the reason is that there's something, if it's any other reason, those are generally like either a client who's kind of problematic to deal with, or there might be some ethical problem. And I'll show you those in a second, like what those reasons could be behind this. Just to show you real quick what this looks like for the individuals, this is Austin McBroom's substitution, where he basically just says like, look, I'm just already my own attorney, and he signed this. And so you can see that's like an electronic signature. There's Austin McBroom's signature. If you have any Austin McBroom Ace Family merch and want to know if you've got a real autograph or whatever, I don't know if that's happened or not, but let's say you did, then now you know what his signature looks like. Just kind of a scribble. And you can see that he's kind of, now he's representing himself. That's already done. And then the question is what happens for the corporation. But again, it's just a form. And now Austin McBroom is being his own lawyer for now, which is, again, not good for him in terms of the chances of him winning this lawsuit. Those of you who are real interested in the law, which hopefully you are if you're watching this channel at any length, these are the rules of professional conduct that explain sort of what attorneys can and can't do when it comes to ending like a attorney-client relationship, and when you have to, because sometimes you actually have to as an attorney. And this is California, so it's just I'm using it as, it's the one that governs here, and it's a good example of sort of how it works. A lot of states use different versions of this that were made by the American Bar Association. California's are a little bit different and more customized, but the American Bar Association in many states has what are called model rules that the American Bar Association made for how attorneys should act. And many, and I would say probably most states follow that pretty closely, but not California. We have a little bit different stuff out here. So California has two sections. One is where you shall withdraw as an attorney, where you have to. And the second part is a list of like times where you may withdraw as an attorney. And these are just kind of examples of what can happen. You can see that you have to withdraw as an attorney, like you have no choice. Let's say if you know that the client is trying to harass someone or maliciously injure a person with a lawsuit. So you basically can't go help a client sue someone if they're just trying to like don't have a real lawsuit and are just trying to harass someone. You can't if you know that you're somehow going to have to violate the rules of of professional conduct. You can't if like if the attorney gets real sick physically, or if attorneys have a mental breakdown or something, which there's hundreds of thousands of attorneys, so that's happening. That does happen. If it makes you if it makes it unreasonably difficult to keep representing them, then you have to withdraw. Or if the client fires you, you can't just like keep representing the client if they fired you. But there are also situations where the attorney may withdraw. That means it's your choice as a lawyer. You don't have to keep going, but you can withdraw. This is where so like if the client insists that you try to like argue something that's not supported by the law in good faith, you can withdraw. If the client insists on, or sorry, if the client seeks to pursue a criminal or fraudulent course of conduct, or has used the lawyer's services to advance a course of conduct that the lawyer believes was a crime or fraud, you may withdraw. That may sound weird to you that the lawyer doesn't have to withdraw if the client is trying to use your services to advance a crime. There are sort of exceptions to this. You see there are asterisks about this. It is something that probably like as a lawyer, most of the time you would want to withdraw in this scenario, but it just gets real complicated, I guess, and the state bar is sort of trying to create outs if you are not actually the one committing the crime. But I do think it's something where, like, if the client is doing stuff that is not up and up, like you see, like here, the client insists that the lawyer pursue a course of conduct that is criminal or fraudulent. So one option you might have, they're not really saying you can go commit a crime, but one thing you could do is say, no, I won't do that, but I will keep being your lawyer. And there's whole like opinions written about like how to handle that, where you're supposed to be like, no, no, no. And one thing that could happen is the lawyer could be like, no, I'm not doing that. And the client says, okay, I won't make you do it. Then the lawyer could keep representing them. But if, it is something where that's the type of client that a lawyer would be looking at and saying, I probably don't want to keep representing you. Most lawyers are, you should at least have some qualms about wanting to keep going with a client like that. It says another one is like the client renders it unreasonably difficult for the lawyer, and that could be all kind of things. If the client's just a little bit crazy, or if they won't give you documents, or they won't go to their deposition, or things like that. The client breaches your contract with the lawyer, and you give them a warning. The client says it's okay, right? So there could be no reason at all if the client is like, okay, I'm fine, you can withdraw. You don't think you can work for the best interests of the client, or sorry, you can't work with co-counsel rather. So co-counsel just means another lawyer. Like if there's two lawyers on the case, you are having problems with the other lawyer, you think that like you can't work with them and it's better for you to just go away, then that's a reason you could not want to. If again, mental or physical condition, if it renders it difficult, if you think it's likely to result in a violation of the rules, but hasn't yet, or if you believe in good faith that the judge, the tribunal, they call it, will find the existence of good cause for withdrawal. And they kind of lay out here like you have to, there's things you have to do. You have to refund fees that aren't earned. You have to give the client access to their files. You have to take reasonable steps to avoid prejudice. That's what I was talking about earlier in terms of like not just not showing up to a hearing. You have to sort of make sure the clients are kind of protected. And all this stuff is like bar exam type questions. The reason why the bar exam is so hard is you have to like know what would happen in all these scenarios and kind of memorize like a significant part of this to make sure that people aren't kind of just messing around with clients. But so it is possible for lawyers to withdraw. It's possible even if you want your lawyer to keep going that they'll say no. We don't know what happened here, but these are just like kind of a list of examples of reasons why this could have happened. Who knows? But the upshot of it is that Austin McBroom now does not have a lawyer in the case, which is very bad. It's been about a month since this withdrawal happened, which means that's part of why it's a little concerning if you're Austin McBroom, because he may either not have access to a lawyer or not have the funds to pay the lawyer, which in terms of like fighting the lawsuit, it is very hard for someone to fight against a lawyer if you are not one, because the lawyer's going to know the rules, the lawyer's going to know how to do everything. Austin McBroom sort of trying to win this lawsuit on his own would be pretty hard. And Jarvis, from his perspective, I mean, the one problem is like if this is because of lack of money, then it does suggest that he may not get anything. There may be no gold at the end of the rainbow for him to sort of recover. But as I sort of talked about in one of the earlier videos, is that he may it may be like frankly better for him than getting $1 million to get a YouTube channel with 20 million followers if he can get that. He may be able to get other things. He may be able to get intellectual property rights. And he may just sort of want sweet justice and revenge after having not been paid for his fight, and may just say, whatever, I'll just hold on to this judgment. And if Austin McBroom ever makes any money, then I'll go grab that money, which is what can happen. You can have that judgment for a long period of time. And that could be a problem for Austin McBroom. So what will happen? We will see. There are hearings coming up in this case. I'll keep y'all updated if anything new happens. And if we suddenly see the Austin McBroom Ace Family channel turn into the Jarvis channel, then I'm sure there will be a lot of drama relating to that. So if you're interested in this and want more updates, hit subscribe. There's probably other videos on the end cards that you can look at that might have other cool celebrity lawsuits or legal questions or in-depth analysis of all these kind of things that I do.